Hello and welcome back to the Data Privacy Lawyer. Today's review is going to be on the AI terms offered by Facebook. So we're doing a series on the channel right now. We're looking at different AI terms of service, public-facing documents related to how artificial intelligence is used by organizations. So we're going to be looking at Meta's AI terms of service. The first thing I want to take a look at is the last time this was updated. So this was last updated July 1st, 2025, which was about 6 months ago. So let's take a look at the provisions. So these terms of service apply when you access and use Meta's AI and other software tools, services, documentation, content, functionality, and generative AI features that we may make available to you through any Meta product. So I think one thing that I would do as a privacy lawyer is I would ask a potential customer or client to identify all of the products, because these terms of service would be presented on all of the Meta products that are referenced here, and ensure that there is a transparency component in all of the provisions in the terms of service that are applicable to the product. So let's say, for example, you had a bottle of water, a microphone, and a laptop, right? If the terms of service that a company puts on their website says any product, all of the processing that is associated with each of the products needs to be displayed on the terms of service. You can't leave any out, which is why I think it's very important for companies to be very specific about updating and reviewing their terms of service. Because if you're making a representation that any of your products are covered within this terms of service, you need to make sure any brand new products are also incorporated into the provisions on the website. So we're not going to look too much about eligibility. I want us to focus on the data protection component, which is the prompts, results, and other content, right? This is very important. So before Meta decided to create any type of product, they probably took a look at what types of inputs and outputs are associated with the AI products here. And that is the information that they're providing here. Artificial intelligence allows you to provide materials for processing, which could include text, documents, images, or recordings. So automatically we can already see, at least at a minimum, 2 different personal data elements. So we know images and recordings are there, right? Now, the reason this is really important, and I wanted to call out this information, is because there are a lot of nuances in data protection laws on how images or recordings can be processed. In some instances, some data protection laws would see a voice recording as a sensitive data element, which is why it's really important to take a look at what constitutes personal data in each geography. So one thing that a data protection counsel like myself would do is take a look at all of the geographies where this terms of service is being displayed and ensure that any appropriate representations associated with personal data are displayed here. Some data protection laws are going to say, if you are processing sensitive data, you need to obtain consent, right? So in some geographies, at least at a minimum, these recordings, these voice recordings, are going to constitute sensitive data and cannot be processed without obtaining the consent of the consumer or the individual, okay? So every sentence that you see on a terms of service, it means something, and it has a ramification under the data protection laws depending on geography. If Meta is stating that this terms of service applies through any product, another question that a data protection counsel like myself is going to be asking is, where are these products being sold? Because it's more likely than not, this personal data is going to be collected in those geographies. And we need to make sure that any information that is required under the data protection laws to be displayed in the terms of service are displayed. Okay, let's get back to this. Depending on the integration, and will generate a response output based on your prompts, as well as any feedback you provide. Now, this is really important, and I'll tell you why this is important and often gets scrutinized by privacy lawyers. Generally, whenever feedback is being provided, it's an open text box, which means that organizations can anticipate what type of information might be put into feedback, like, oh, I like the product, or oh, I don't like the product. But because it's an open text box, we can't qualify it like we can qualify a voice recording or an image. So there's a lot of decisions that go into what type of feedback can be provided in these open text boxes generally, and what companies can do on the back end is they can put in place configurations that don't allow certain words or phrases to be placed into the feedback because companies don't want to process it. So I'm just giving you some insight based on the review that I do for my own clients, and generally like what I tend to see in the industry when it comes to using artificial intelligence. If your company is looking for assistance from a legal perspective on how to, one, create a terms and service for the artificial intelligence products that you either create or utilize, or you're looking for how to comply with the artificial intelligence legislation, you can take a look at my description below, and I have different links that you can use to contact me in the event that you need assistance with these documentations. Okay, collectively content. You may not provide prompts or use AI in any way that infringes or violates someone else's rights, including intellectual property rights. Now, this is very interesting because generally with laws, they are often interpreted in silo. With artificial intelligence, there's lots of legislation that is used in consideration when drafting these terms of service, specifically to do with intellectual property rights. So there's a lot of discourse right now in the data protection space about where the legislation is going to go in the future when it comes to artificial intelligence. Right now, there's a lot of discussion because there's few artificial intelligence legislations. Most of them at this time really focus on high risk processing activities, but there's going to be a whole host of interpretation coming out of different regulatory bodies on the use of artificial intelligence, and intellectual property rights is one of those current discussions, because what's happening is that some of the prompts that individuals are using, the outputs that are created could infringe on intellectual property rights that other individuals have, whether it be patents, whether it be copyright, trademark. All of those issues are still at play when it comes to artificial intelligence. Now, that could overlap with data protection in that, depending on the intellectual property that is being discussed, whether it is a work of art that a person has created, this is discourse that is still up for debate and is definitely something that organizations should be considering, which is why we can see that Meta has put this disclaimer about not providing prompts that are going to violate someone else's rights. Now let's look at the personal information component, and the next time I do this AI review, I'm going to focus exclusively on the personal information because that's what we do here at the Data Privacy Lawyer. The Meta privacy policy governs our processing of personal data collected through the AIs. Okay. And explains how we collect, use, and share the personal information. When information is shared with AI, the AI may retain and use the information to provide more personalized outputs. Now, this is interesting, and what I anticipate, I haven't used the AI products for Meta, but I can speculate that it's likely that any AI product that's used by a consumer is going to have a page reflected requesting permission to provide more personalized outputs. Now, there's two different things that are going on. One, we've got this notice, these terms of service that are displayed to consumers. And then there's the actual process flow when it comes to using these AI products that are listed above. When a data protection counsel is drafting these terms of service, generally the stakeholder or customer is going to display the data flow when it comes to using the AI product, because that influences the provisions that are placed here. It says here the AIs may retain. The use of the word may tells me that it's a permission thing. This is not a mandatory requirement for using the AI product. And then we can also see provide more personalized outputs, which generally gives me insight that it's likely that a permission box is presented to consumers if they want this feature. Do not share information that you don't want the AI to use and retain, such as account identifiers, password, financial information, or other sensitive information. Meta may share certain information about you that is processed when using the AI with third parties. Now, this is interesting. I think it would be useful for organizations to display who those third parties are from a transparency perspective. I don't see that in the terms. However, it may be that it is displayed in the privacy policy. Generally, from a transparency perspective, organizations should be displaying who their subprocessors are, and subprocessors is a privacy term that generally indicates a third party that is utilized by, for instance, a processor. So it really does depend on, the geography. That's really important. Different geographies have different definitions for what constitutes a subprocessor, but essentially it's a third party that facilitates a processor to provide services to an organization like a controller. So I really hope you enjoyed this review. The next time I do an AI terms review, we're going to focus on the personal information provisions because that's what we do here at the law firm. I hope you enjoyed this audit. I will see you in another one.